planning and elder law, things to be aware of, what are the important documents that you should consider as part of your estate plan. And we're going to go over a lot of items. And I'll stop every so often after I talk about a topic and take some questions. First thing I want to talk about are powers of attorney. Are people familiar with powers of attorney? Please raise your hand if you know what they are. Okay, so everybody has most people have some familiarity with powers of attorney. And what a power of attorney is, it's the key, most important financial planning document that exists in the estate planning world. It's a very, very powerful document because it's a document where you're appointing somebody as your agent to handle your financial affairs so they can take care of things if you're unable to handle those affairs or are not available to take care of your affairs. Now, one thing to know about powers of attorney is that they are documents generally that when you sign them, they become immediately available for use by the person that you appointed. You don't have to first be certified that you're incompetent or disabled. Most general powers of attorney that you see, like the one in the materials that you have here, can be used by the agent after it has been signed by both you as the principal and the person that you appointed as your agent. Let's take a look at the power of attorney document that's in the materials in the book that you have here. And you'll see it on page 127. So let's turn there. And what you have on page 127, or actually it starts on page 129, is the New York State statutory power of attorney. That is the form that all banking institutions licensed to do business in the state of New York must recognize, or they are subject to sanction. Okay, so many times you go into the bank and they say to you, oh, you got to use the Chase form, you got to use the Bank of America form, power of attorney. You have to use the Merrill Lynch form, power of attorney. The answer is this power of attorney must be recognized by all of those institutions doing business in New York, or they're subject to fine. So it's a very useful form to use so that you don't have multiple power of attorney documents at many different institutions, and that's why I'd like to review it with you. So in a power of attorney, you'll see on the first page, there's a caution, again, and I caution everybody here as to how powerful a power of attorney document is, in that a person can immediately, upon it being signed, take your assets, drive off to South America. So you need to know that the person that you're appointing is somebody who you trust implicitly. It's key. It's very important. You can name one person, two people, three people, multiple people, but then the question becomes, are those people, must they always act in concert, jointly, so we are always requiring consensus before things can be done, or can they act independent of each other? Generally, I recommend to clients, if we have, if the family is intact and all the parties are getting along with each other, that you consider allowing agents to act independent of each other. Why is that? That way one agent may be around and can take care of things. Another agent, when that agent's not around, the other agent can act, and so forth. We don't need multiple parties always having to agree before an action can be taken. Instead, we have an arrangement whereby people can act as they are available, which makes the document so much more flexible. So that's the way that we like to act. Just related to powers of attorney, sometimes people will ask me, well, why do I need a power of attorney? You know what, I have a joint account with my parent, and that allows me to take care of her banking affairs because I'm joined on the account with them. And that's true, but what sometimes people don't realize is, you ever see those letters on an account that say JTWROS? that familiar? I see some nods around the room. JTWROS stands for Joint with Rights of Survivorship. And what happens is you put somebody on a joint account with you, you've now given them inheritance rights in the funds that are in that account. Because when the parent passes away, the child who is the joint holder with the parent now owns the assets in that account, irrespective of what your will says. Because a will only controls assets that you own in your individual name that do not have a beneficiary. If you have an account joint with someone else, you pass away, we don't need a will, it goes to the survivor. You have an account that names a beneficiary, we don't need a will, like we're talking about life insurance, IRA, other retirement accounts. The beneficiary designation form is your will. It says when you die, where the assets go. A will only governs those assets that are in your single name that does not have a beneficiary on it. So you have to be very aware of how you own assets and why a power of attorney can be very important to use instead of taking somebody and making them a joint owner with you. So if you have, for example, let's say you want to leave your assets in 3 equal shares to 3 children that you have, you have several accounts, but you have one child who lives nearby as a joint owner with you, yet the will says that you leave all the assets in 3 equal shares, then what happens is, at the time of passing, irrespective of what the will says, all of the assets are going to go to the one child. And people don't realize that sometimes. They say, gee, I have a will? Well, my will takes care of my affairs. It doesn't take care of joint accounts because by contract, it goes to the survivor. It doesn't take care of beneficiary designations because you have signed something indicating who you want to be the beneficiary of a particular account. So very important to follow that. Going back to the form that we were looking at on the power of attorney, you're going to see that a whole host of various actions that the agent can do on your behalf are listed as letters A through P on one of the pages in the materials there. It starts at the bottom of the second page of the power of attorney and carries on into the third page. And this lists various actions that you may want the agent to do on your behalf. Sometimes you want to limit it to there's something called the limited power of attorney. Maybe you want somebody only to handle being present at a real estate closing for you. You're selling your house, you're not able to be at the closing, but you want to trust somebody just for that limited purpose. You can limit the power of attorney just to real estate transactions. Maybe you want somebody just to be able to handle your banking. You can limit it to banking. But more often than not, you'll find that people will sign powers of attorney in favor of people that they trust implicitly, and they just say, I want it to be a general power of attorney. I want the agent that I appoint to be able to do everything and anything that they believe to be in my best financial interest. And that ends up being a general power of attorney. And you can, on the form that you see here, by letter N, you just initial there, it says all other matters, and you can take care of things there, and initial letter P that says all of the items below are included as part of the general power of attorney. There are important aspects to a power of attorney to also be aware of. It's very important for purposes of either tax planning or in the context of trying to qualify for Medicaid, that people be able to transfer their assets in order to reduce tax liability or in order to qualify for the Medicaid program if the family member has become ill and requires what we call custodial care. Not skilled medical care, but we're talking about custodial care, where they need assistance with the activities of daily living, eating, bathing, dressing, etc. To qualify for the Medicaid program, I'll talk about this in a little bit more detail shortly, you can't have, as a single person, more than $14,850. So many times it's necessary to be able to gift away or transfer your assets away. But if you have a power of attorney, you want to make sure that it also has a gift rider. Because only by having that gift rider attached to the power of attorney, you'll see it in this section of the book, that there's a separate gift rider there. That is the way to make sure that you're giving authority to the people that you appoint to give away your assets. And now you have to really make sure that you trust who you've appointed so that they can act in your best interest, either to reduce tax liability or to qualify for the Medicaid program by moving assets away from yourself. So when you're doing the power of attorney, give thought to also executing the gift rider that goes along with it if you're comfortable giving your agent that much authority. Very, very important. Questions on powers of attorney? Please don't be shy. Anything that I haven't mentioned about powers of attorney that you'd like to know about? Yes, ma'am.
It can be very short, and my husband was going in for surgery, so he gave me a 2-week power of attorney. You might mention that.
Okay. The point is being made that you can limit in duration for how long a power of attorney can be used. That's not commonly done, but it could be done. You could build into the modification section of the power of attorney that this power of attorney is only valid for the next 2 weeks. To get past the surgical procedure, that could be done. Other questions on powers of attorney? Yes, sir.
Would an organization like a church or a law firm be a power?
Generally, an organization can't be an agent by itself, but for example, many times there are organizations where they have fiduciaries who will act for you, but you got to be very cautious entering into arrangements like that. And also law firms where attorneys may act, but generally attorneys are kind of reluctant to act as your agent in a financial document like that. But it can be done, and in some instances where somebody doesn't have anybody else to appoint, that can be done. I look at that really as a matter of last resort. Yes, ma'am. Can you change it? Yes, you can change your power of attorney 3 times a day if you like. Okay, so and it's important to understand that because people get very concerned. I sign a document and it's in stone. Okay, power of attorney is not in stone. You can change it, but there's a procedure that you have to follow. You have to sign what's called a revocation of power of attorney, and it's a 1-page form, and you revoke it. But you must give a copy of it to the people who you appointed in the first document so they know that their authority has been revoked. You should give that revocation to all of the banks that you've given the power of attorney to. Some people, I even recommend that they file it with the county clerk's office so it's a public record. So it's a bit of, sometimes if you've had a falling out with that person, if that's why you're changing it, this can be difficult. But it certainly can be done. Yes, ma'am. I'm really glad that you asked that question. So this lady has a power of attorney that only goes into effect if she has diminished capacity, if she's not well enough to take care of her own affairs. And I've prepared powers of attorney like that as well. I don't encourage them for this reason. When you use a power of attorney like that, it's what we call a springing power of attorney. It springs into effect when a doctor certifies you're of diminished capacity. And that requires, in order for the power of attorney to be used, to first get a letter from the doctor confirming you're of diminished capacity, then taking that letter together with the power of attorney form, and then give it to each of the financial institutions where your assets are. What you'll find with powers of attorney, financial institutions hate them. Okay? They know that they have to be used, but they sometimes make it difficult to be accepted. And once you introduce also an a physician's letter, it just complicates and slows down the process. But some clients, they don't want anybody to be able to act unless the doctor certifies they're not capable of acting on their own. If that's the case, you feel strongly about that, there is the option called the springing power of attorney. Thank you for mentioning that. Okay, I'm going to move, last question on power of attorney. Yes, sir.
On follow-up, what if there is a divergent view between yourself and your designated attorney? Who gets precedence?
I'm sorry, if there's...
Understand the question.
Yeah, just say that again so I can...
If there's a different
Version of the document? There's
Different of what you do.
there's a disagreement. Okay, that's a great question. So if you've appointed where people have to act jointly, well, then they have to reach agreement. If they can act separate and apart from each other, well, then you have one person doing one thing and then the other person reversing what they've done. Situations like that need to be either the parties have to come to agreement to work together, or if they can, unfortunately, that you're going to end up in a lawsuit. That's what will happen. So you got to be very mindful of who you're naming, and if you're naming multiple people, are those people going to get along with each other? So I'm glad you raised that question. All right, I'm going to go on to, and there'll be some kind of questions at the end.
He was asking about the person who pays the POA, not the person, not having multiple POAs, but having me giving somebody else control. I disagree with what they're doing.
Then you revoke the power of attorney. Okay, that's the question from before where somebody said, can I change it? Not only can you change it, but you can revoke it, terminate it, end it, okay, at any point in time, okay? All right, I want to go on to healthcare advance directives. We just finished power of attorney, the financial advance directive. Remember, powers of attorney, you use them during your lifetime. When you die, power of attorney dies with you. And that's when your will or trust or joint account or beneficiary designation takes over. Very important to know. Same thing is true of healthcare documents. The primary healthcare document, you can look in the materials there, is the healthcare proxy. So take a look at the healthcare proxy that is in the materials. You'll see it in the table of contents there. Somebody could announce what page it's on, that would be great. 80, I'm hearing 84. Okay. So if you turn to page 84, and actually the proxy itself I see starts on 89. On page 84 is where the instructions for the proxy start. But turn to page 89 just so you see how the form itself sets up. And in a healthcare proxy, unlike the power of attorney that we were talking about, it doesn't take effect until a physician determines that you cannot make your own healthcare decisions. So you do remain in control with a healthcare proxy throughout, and you're making your own healthcare decisions. So it's kind of like a springing document. Here, unlike the power of attorney, where you can appoint one person, two persons, say they can act independent of each other together, however you want to do it. Not the case in a health proxy. In a health proxy, people can only be named in succession. You have person number, either your son first, followed by your daughter, or vice versa. And you have to be very mindful of that, because really one person is the ultimate decision maker on that document. And it's different than the power of attorney arrangement where you can name joint parties. Healthcare proxy can be used for all types of healthcare decisions, including making decisions about withholding or withdrawing life support. If you feel strongly about not being kept alive by artificial means if you were in a persistent vegetative state, then I'm going to suggest that you might want to consider also signing a document called a living will, or another document called a MOLST form. And how many of you have heard of a MOLST form? Because that's only been around about almost 10 years now, but it's first I see a few hands going up. MOLST, it stands for Medical Orders of Life-Sustaining Treatment. And the medical order of life-sustaining treatment is a document that people will use as an advanced directive where you sit down with your doctor and you go through all the different choices that may need to be made in connection with end-of-life planning. And not only do you sign that document, but the doctor also signs the document, thereby making it a medical order. That's why it's called medical orders of life-sustaining treatment. They become more commonly used, and many times people who have chronic illness of more advanced age will consider using a document like that because it has the force of being a doctor's order. So be aware, and there is a MOLS form in the materials that you have there. Take a look at it. It's an interesting document, and I have a lot of clients who've sat down with their physicians and worked them through. So those are the healthcare advanced directives. Healthcare proxy being, in my view, the most important because you want to designate somebody to make your healthcare decisions. Understand that if you do not have a healthcare proxy and you became incompetent, New York State has what's called the Family Healthcare Decision-Making Act, and that means that New York State has determined who your healthcare agent will be, and it's a priority list. It'll say spouse first, then children, etc. But it may end up being somebody who you never would have been wanted in charge of your healthcare decisions. So be proactive and sign a healthcare proxy. And one of the workshops going on in the second session, you can sign healthcare proxies. There'll be witnesses available. So questions on healthcare documents? Yes?
Does the MOLS take priority of the healthcare proxy? And if so, then should we just do the MOLS rather than the healthcare proxy?
No. Okay, they're kind of they work in tandem together. The MOLS form, the physician is signing off on what your wishes are for end-of-life treatment. But the one who implements that, the one who's got to carry out your wishes as set out in the MOLS form is your healthcare agent in the proxy. Okay, so thanks for asking these questions. You need the two. Either you're going to have the healthcare proxy together with a living will, or healthcare proxy with a MOLS, or some people don't want to sign end-of-life forms at all, then just have a healthcare proxy. But you always want to make it clear to your agent what your wishes are. Very important. Yes, sir.
Is it a good idea to include a provision in the healthcare proxy specifically authorizing the agent to make decisions on behalf of a principal in situations where the principal is clearly unresponsive, even if the determination of incapacity has not been made by the physician?
Well, if the determination, it has to be that the person is unable to, doesn't have capacity. If they have capacity, they'd be making their own decisions. If they're not acting at all, the physician may say, gee, this person is not responsive, is not, you know, okay. I mean, a person can decide to take no action. That may be their decision, is to do nothing, okay? And they're entitled to do that too. But if it's determined they're doing nothing because, you know, they're not competent, well, yeah, then the healthcare agent can act, okay? I hope that's responsive. Okay, I'm going to move on now to wills and trusts. And what is the difference between uses of wills and trusts? When might you use a will and when might you use a trust? And there are different kinds of trusts. And I'm going to touch on this because there's so much information out online, articles written for years and years on, you know, having a trust. And I really want to, you know, kind of go through it with you so you understand better and it helps you make a decision one way or the other, what suits your circumstance best. So let's start. Everybody knows what a will is, okay? And you know, a will is a document where you're setting forth how you want your assets to be disposed of when you die. And it's a document, though, that when you die, in order for the will to be effective, and can carry out your wishes and distribute the assets to the beneficiaries that you name, there's a process called probate. You heard of that process, probate? Usually that's puts fear into the heart of many people. Probate means that when you die, you have to take the will and bring it to the surrogate's court. We had surrogate Saul, who was sitting here up on the table before. It's his court that receives all the wills. And they look at the wills to make sure that they were properly signed and that all parties who would inherit your assets if there was no will have been given a copy of the will and has an opportunity to object to its terms. So what do I mean by that? I mean that if you don't have a will, New York State sets up a will for you. They tell you who is your next of kin. So it might be that your closest relations is a spouse and children, or nieces and nephews. Once it's determined who your closest relations are on this chart, those are the only people who can object to your will, because if there was no will, they're going to get your assets. Okay, so sometimes I get clients who come in and say, I want to leave my assets to two of my nephews, I don't like my nieces, I'm not giving them anything. And you're entitled to do whatever you want, and that's fine. But if you have a will, when you die, the will is brought to the court, and the nephews are given a copy of the will, and the nieces, who aren't being provided for at all, also get a copy of the will, and they have an opportunity to object. It has to be a legitimate objection. They have to be able to come forward and say, gee, Aunt Jen wasn't competent at the time she signed this will, she was taking medication, I know she wasn't on her game, etc. Or she was under duress. That nephew, who she left her money to, always moved in with her and kind of took over her life, and she really did this under duress. You have to make legitimate objections, and then there has to be a hearing, and there's a whole court trial potentially to determine whether that's a legitimate objection or not. But the point is, if you're not leaving your assets to your closest heirs, whether that's a spouse and children, nieces and nephews, aunts and uncles, first cousins, whatever may be your closest relation, then going through the probate process may not be the right choice if you think that you're going to have objections by those closest relatives. So you're leaving your assets to your nieces and nephews, but you have a child, but it's an estranged child. Maybe using a will in that circumstance isn't the best choice. Or, and I get these cases several times a year, client comes in and we always do a family tree, and they tell me their closest heirs are, and this year I had 21 first cousins. That's the closest relations. And the person says, some of my cousins I'm very close to, and quite honestly, a few of them were in Europe, I never even met them before. Never do you want to use a will in a case like that. Why? Because the probate process requires, even though you're leaving your assets to two of the first cousins and your best friend, the court will require you to locate all of the first cousins, to present them with a copy of the will, and tell them that they have a right to object. Not that these people are going to object, because but the cost that goes into locating heirs, they have companies that serve as heir search companies, is prohibitive. It's usually expensive and will take generally a couple of years to get through before the court's going to say, you've done your due diligence, you've located your closest relatives, and we approve the probate of the will. When the probate of the will is approved, what happens? The executor is appointed, and they get a little certificate. You ever hear the term letters testamentary, and you hear that term at all? That means the letters testamentary is the certificate saying the will's been approved and John Doe has been appointed as the executor. That means you've gotten through the process. But in some of the examples that I gave, another way to approach the issue might be to use a trust. Because what happens with a trust? A trust is an agreement that you sign where you can even be your own trustee if you want to be, or have other trusted people be your trustee. And it determines how your assets are managed while you're alive, but you're in control. So it's a trust that you determine the terms on, and you can change at any point in time. So Mary Smith transfers her assets into the Mary Smith Trust, of which Mary Smith is the trustee. But you have to retitle the accounts into the name of the Mary Smith Trust. So if Mary Smith has a bank account, it's got to be transferred into the trust. Mary Smith owns her home, a new deed has to be prepared, transferring to the trust. So you see there's a lot of steps to having a trust. But the benefit can be when Mary Smith dies, and maybe she was the person with the 21 first cousins. It's a private document. It never goes to the surrogate's court because it doesn't have to. Only wills are probated. Trusts are not probated unless you left some assets that are not in the trust or are not jointly held or do not have a beneficiary designated. So many people will settle their affairs by putting certain assets in the trust. Certain assets they have beneficiary designations like retirement accounts or life insurance, and maybe they have a joint account on certain assets as well. And that will avoid probate. Okay, so just understand that difference. But many times clients say, you know what? My closest heirs are my 3 children. I'm leaving my assets to my 3 children. I'm going to do a simple will. I don't have to run around transferring my assets into the name of this trust. And that's fine too, because that probate will be a simple probate and things will happen rather quickly. The probate court does have fees, however, so you should be aware of them. The highest fee that the state of New York, the probate court charges is $1,250 for estates that are valued at more than $500,000. Okay, so those are differences between wills and trusts. Some people like trusts because they streamline things while they're alive. They bring all their assets together under the terms of one document that they control, and on top of that, it's all lined up for what happens when they pass away. So they like that streamlining. Many people are just as comfortable settling their affairs by will. So important to understand the differences, and everybody's circumstance is a little bit different. It depends who your closest relations are, and what are your relations with your relations. Okay, that's a key question too. So I hope that gives you some insight into wills and trusts. The type of trusts that I've been talking about are revocable trusts, meaning that you can change them, alter them, modify them as needed. There are also documents called irrevocable trusts. Irrevocable means you can't easily change the document. And those are used either for tax planning purposes or, which I'll be speaking about in a moment, in the Medicaid arena, sometimes we use irrevocable trusts because you have to move the assets away from you in a way that you can't get them back. You can give them to a person or put them into an irrevocable trust in order to qualify for the Medicaid program. So before I go toward and start talking about irrevocable documents and Medicaid and so forth, questions on wills and trusts. Any questions? Yes, sir. Pour over will, yes. Yes.
Can the will be contested?
Yes, any will can be, any trust can be contested too, but since a trust is a private document, it's more difficult to know what's going on. But a pour over will, just so people know what that is, when you do a trust, most of the time the attorney's going to prepare a will also that says, maybe you forgot a document. I get clients all the time. They leave some savings bonds in the drawer that they forgot about. They have an old bank passbook, well, you see less of that now, that they forgot about. And it's still just in their name. So they have this pour-over will that says, okay, you forgot to put some of your documents, some of your assets into the trust. So here's the will, and what does the will say? That I pour over any assets that are still in my name at the time of my death into the trust, so it passes out in accordance with the terms of the trust. But you have to still probate that will. So many times clients will say, I got most of my assets into the trust. You know, it's just about, I left like $10,000 of assets out of the trust. and I'll say, well, you know what, you got a probate for $10,000 or $10 million. It doesn't matter, it's going to be a probate. So you're best off usually making it so that either you're non-probate or you're probate and not a mix of the two. But you want to have that pour-over will to make sure that if you forgot about assets, and it does happen frequently, that they didn't get retitled when the person died, at least we have something that says that the assets are still going to pass out the same way as the trust says. Questions? Yes?
If you have a beneficiary designation.
If you, I'm sorry, if you...
If you have a beneficiary designation.
Yes.
Does it override the wills and...
Yes. Beneficiary, I can't emphasize that enough. Beneficiary designation form countermands anything you write in your will. But guess what? A lot of people will write in their beneficiary form the word estate. Okay? What does that mean? Now they've just turned it back over to the control of the will. All right, if they have one. Or if they don't have a will, then that body of law that I mentioned before that names people who are your beneficiary. It's called the law of intestacy. So be very careful when you name your estate as your beneficiary. Make sure that your will is going to the people that you want it to, because if you say estate, then your will gets back in the game. And in the retirement world, on IRA accounts, 401k accounts, 403b accounts, 457 retirement accounts, whatever retirement account that you have, you want to be very mindful of not using the word estate. You're better off naming individuals, because an estate has to take out all of the retirement money that has never been taxed before over a 5-year period. Whereas an individual many times can take it out over their lifetime. So they don't get taxed in such a short period of time. So that's something to be aware of. Okay? And I'm sorry, I'm sorry, yes?
Yes.
Yeah,
I have an irrevocable trust. I want to change.
okay, your irrevocable trust. Okay, so let's talk about that. That's tricky.
I know.
And we do it, it's done all the time, but it doesn't, it will depend on the following. New York State has a law that says that you can revoke the irrevocable. But of course, there are rules on how you go about revoking the irrevocable. And those rules are, all interested parties in the irrevocable trust have to agree to change the document. That the old one's being revoked so you can make a new one. Who are the interested persons? They are, of course, you. They are your trustee. And in an irrevocable trust, generally you're not your own trustee, it's somebody else. And the primary beneficiaries that you name also must sign the revocation document.
But what if they're not around?
Then you can't read, then you can't, you signed an irrevocable document, you gotta be really careful, you're stuck. Okay? There are other ways out of that if the document has something called a power of appointment in it. But it's difficult to revoke the irrevocable, but it can be done. You really need to sit down with a lawyer to get that done. Okay? One more question here, and I want to devote just a little bit of time to the Medicaid rules. I'll take two. One, two. Go ahead, sir.
Going into service court,
Yes.
I know there's 2 types of form. There's one that's,
One's probate and one's administration.
and one is very small. What is the cutoff point?
$30,000. So there are small estate proceedings that if your estate, when you die, is worth less than $30,000, can be handled in a more short form way that is more conducive to the public being able to do it. But once the estate is more than that, it's a full probate. Yes, ma'am. Yes.
Do you justify an income tax for the estate, with a trust?
Okay, so just briefly on taxes. A trust, if it's a revocable trust, you pay taxes on it like you owned it yourself. Okay, there's no difference because you can change the trust, revoke it, modify it, do whatever you want. No separate tax return for the trust. You don't need one. You just pick it up on your own personal 1040. Okay, no difference. Irrevocable trust, depending upon what kind it is, many times will have their own tax returns. And you have to be mindful of that, because sometimes things will be taxed at a higher rate than they would if you owned the assets yourself. It depends how the trust is drawn, okay? I mean, I could go into a lot of detail on that, but we don't have the time. But just be mindful. Revocable trust, you don't need a separate tax return. Irrevocable trust, you may or may not need a separate tax return, and things may be taxed at a higher rate. All right, I'm going to move on to Medicaid, and I'll have questions at the end if people want to talk about things further. The world of protecting assets long-term in the event of a long-term health care crisis. The type of health care crisis I'm talking about is one in which the person has reached a point where they need assistance with activities of daily living, whether those activities are assistance with bathing, transferring, getting out of bed into a chair, eating, toileting. There's a list of about 6 of those items. And in those circumstances, Medicare doesn't cover you beyond short periods of time here and there following a hospitalization, maybe up to 100 days at most if you're going through a rehab process. But after that, Medicare is designed to cover skilled nursing care. So what are the options at that point? Well, the options are perhaps you purchased a long-term care insurance policy. Are the people here who have purchased those policies? Okay, I see a few hands going up. That can be very helpful, and that's what they're designed for, to pick up where Medicare ends. Okay, when you need services at home by an aide, or you're in an assisted living facility, having an aide for you there, or even paying the assisted living bills themselves, and of course covering nursing home care. But long-term care insurance is expensive, and it's something that you really want to think about, in my view, certainly in no later than your 50s, because once you start getting beyond that point, it becomes very, very costly. But it can really be a real safety net and allow you to control your assets by having long-term care insurance in place. But if you don't have long-term care insurance, and you want to protect your assets in the event of a long-term health care crisis, it is possible to try to qualify for the Medicaid program. And you hear that word aid, we distinguish Medicaid from Medicare. Medicare, you're 65 years of age or older, or you're disabled in accordance with federal law, you're entitled to Medicare. But Medicaid is a whole other story, because you hear the word aid, it means that you have to financially qualify in order to become eligible. Financial qualification is very complicated, because Medicaid also has 2 types of programs. They have a community-based program called the home care program, and they also have an institutional care program, the nursing home program. And the rules are quite different. And whether you're married or you're a single person, the rules can be quite different. One thing to know right up front is many people hear, well, there's a 5-year delay before somebody becomes eligible for Medicaid. Well, that's true potentially if you transfer assets. You may have to wait 5 years to become eligible for nursing home Medicaid. But in the world of home care Medicaid, where you're getting assistance from aides at home, there is no 5-year delay. And people don't know that, or a lot of people don't know that. You can actually qualify for Medicaid at home on the first day of the month, after which you have less than the Medicaid threshold of $14,850. Okay? New York State also recognizes a law called spousal refusal, which says that if the ill spouse has more than the $14,850, the assets can be transferred to the well spouse. And the ill spouse can qualify even for nursing home care, where I said there was a 5-year delay. in the case of spousal refusal, it's actually possible to qualify much more, again, on the first day of the month after the person has been brought down below Medicaid standards. I'm just giving you just a little bit of flavor for the Medicaid rules, because income is another test that Medicaid uses. They have an asset test, how much do you have in resources, and how much do you have in income. And many times in the income world, if you're in a nursing home, if you're a single person, all of your income is going to go to the nursing home. Home care, by setting up something called a charitable pooled income trust or fund, it may be possible to preserve the income to use for your expenses. In the material that I gave out, all of this is discussed in a lot more detail. But what I want to talk about briefly is just also to understand that there are strategies, legal, legitimate, disclosed strategies for preserving your assets long term, but you have to be willing to give up control over those assets in order to qualify for the Medicaid program. So that requires either moving the assets away from yourself to be held by children or other trusted individuals, or placing them into an irrevocable trust, not the revocable trust that we were talking about before, where, again, you're giving up control over the assets and maybe making your children or others trustees. Things to consider when using a trust: many times a trust will be used when your assets consist of property that has appreciated in value over time. So what's the primary thing you'll see in Westchester County that you might own that has appreciated a lot over time?
The house.
House. Okay. So many times a client will take the house and they haven't got any counseling from an elder law attorney, and they deed it to their children. They figure out how to do the deed themselves. Somebody helps them at the county clerk's office, or a lawyer friend who doesn't practice in this field, and the next thing you know, the house is owned by the kids. But it's a house that they bought for $100,000 that's now worth, they bought it in like 1958 for $100,000. That house is worth like $1.5 million. Okay? And you see these cases, maybe not so dramatic, but you do see the dramatic ones, and you see even less dramatic. Well, that's a really bad move, because now those kids, when they sell the parents' house, are going to have a capital gain on the difference between 100 and $1.5 million. Those kids are not entitled to the capital gains exemption, the $250,000 per person or $500,000 married couple exemption. They're going to get walloped. And that could have been avoided. How? By, instead of giving the house directly to the children, the house went into an irrevocable trust. Because if the irrevocable trust is properly drafted, for tax purposes, it's as if you own it. For Medicaid purposes, we want to make sure that it's like you gave it away, and you have irrevocably given it away, but we want to do it in a way that the IRS and the New York State Department of Taxation and Finance all say that that they recognize it as if it was still yours. And the reason we want it to still be yours is so that it's taxed like you own it yourself. What does that mean? Number one, you keep your store exemption. You gave the house to the kids directly, it wasn't your store exemption. They don't live in the house, in most cases. In addition, that $250,000, $500,000 exemption, if you set up the trust correctly, that will apply. So if the house gets sold, the first $500,000, if it's a house of a married couple, won't be subject to capital gains taxes. Right? Big difference. And another difference is, when you die, if you own an asset that's appreciated when you die, or you placed it in a trust that owns the asset when you die, then you get something called step up in tax base. Unfortunately, you have to die in order to get that benefit. So the government will give you these tax breaks, but unfortunately they make you go to great lengths to get them. Okay, in this case, death. But to be serious about it, it is a circumstance where the kids now inherit the assets, In the example I gave, at $1.5 million instead of $100,000, they resell it because the children inherit it at the fair market value of the asset when you die, not at what you paid for it originally, and when they resell it, there's no capital gain. So be aware of these planning strategies, and with that I'm going to conclude my presentation. I'm being waved at, not so politely, and I'll stick around a little bit for questions, but I want to give time for the next speaker to also be able to set up. So thank you. Decker's at the door who's going to collect the forms. Okay, thank you everybody. It's a pleasure speaking with all of you.